to bring it back to ECAB, right? So you guys are brand new attorney. Just for clarification, do you do ECABs? Do you write up your own cases when you become felony attorneys?
No.
So in a vertical system, everybody writes up their own case with a felony and misdemeanor, and they keep it. In a horizontal system, you might have a grand jury unit that writes up all the felony cases and then takes them and investigates them for indictment.
So basically, if you are in a vertical borough, you aren't ending ECAB just because you went from a misdemeanor attorney to a felony attorney.
Nope, you still get a rotation. You got to go in there. You might spend a week of nights. Might be there on the weekend.
Not in Queens.
Not in Queens. Okay, not now, but it was before.
No, not in Queens. Because if you're a misdemeanor assistant, you weren't doing felonies. So in Queens, there's an intake bureau. Everyone in the intake bureau, whether it was the old system or new, the intake bureau wrote up cases.
Yes.
Period. And now anyone in intake bureau writes up cases, then it gets assigned out after that.
Okay,
so that's horizontal.
Yes.
Because they're writing it up and it gets bounced out.
Yes, that's it.
Okay, so now what?
No matter if you're a felony assistant, you're never working intake unless you're picking up a shift.
Yeah.
And that case doesn't come to you either.
I wonder why nobody ever leaves Queens.
ECAB. What happens at ECAB? Because we've been talking around it. Like, explain what do they train you to do, and what do you actually do?
So the police officers make an arrest. Mm-hmm. They bring their charges to ECAB. Mm-hmm. You speak to the officer over the phone. You ask them what happened. You get all the facts, whatever it may be. Like we spoke earlier, if something isn't right, the case gets DP'd, meaning dismissed out of ECAB, or intake is interchange.
Decline to prosecute, right? DP means
decline to prosecute. Most cases don't get declined to prosecute because a lot of times you need more information going forward. So the officer articulates everything that happened, whatever their observations was, whatever happened, why they made the arrest, et cetera, et cetera. Based on those facts, you determine the final charges. So like we mentioned earlier, officers sometimes upcharge, don't know the charge, or they charge based on the law, but practically speaking in New York, that's not how the law is prosecuted, so you choose the charges. For example, a lot of fights can qualify for a felony assault too. But in New York, you're looking for that significant injury to have an assault 2. So most cases are prosecuted as an assault 3. That's one example. But an officer will charge an assault 2 and then we'll prosecute it as assault 3.
Or hate crime it up to it.
Yeah, that's PTSD right there.
How many misdemeanor assaults that I had to defend as felonies because they were
That's in
able to
Manhattan?
back it up.
Yeah, that makes sense.
No, my practice now is very different.
No, but when you were
When I was at legal aid,
yeah, I mean Manhattan it has a lot of hate crime issues going on out there.
I'm definitely traumatized from fucking being there for so long.
I can see that. So then you speak to the officer, you find out what happened, you find out, make sure all the elements of that crime is there. You write up the case. A lot of the facts in the complaint aren't detailed facts. They're just facts enough to make out the elements of the charge. And that's it.
That's by design, I would imagine.
Yes. Yes and no. Yes, it's by design, but it's like kind of robotic. It's legalese. So it can mirror another complaint, and certain things are changed, like the name, the date, etc. But you're using legalese because it's the elements of the crime that's listed underneath the complaint.
My question is that is certain things left. So, for example, like the complaint, like you said, has to make out the elements. Mm-hmm. And it's legalese because you guys are using templates or whatever. It's like you're just making sure you make out the elements so it's prima facie on the complaint, right?
Yes, because of the facts that you learned from the cop and also from the complainant. Because if there's a complainant witness, you would want to talk to that person to find out from them what happened, because you're having it hearsay through the cops. You want to speak to them directly.
You need to.
Right, exactly. So it's only legalese because that's how the statute is written. So you have to use the statute's language.
Is there things you leave out on purpose? Are there things you train to leave out on purpose? Or are there things that are you trained to put in certain things on purpose? That's my question.
I think in terms of training, it goes to just the point of being a lawyer. Okay. You don't put detailed things in that one don't matter or two can change. Like you don't want to lock yourself into a red coat if when you look at the video camera, the cop saw it red because of the light on it, and it's really a black coat. But sometimes that matters to like an ID, so you have to do that. You have to cross-reference that. But certain detailed things you necessarily don't want to include, because as a lawyer, why would you lock yourself into it if down the line you have to go forward and prosecute?
The evidence anyway,
Right,
so,
exactly. You have to look into it as well. So I think that it's training. It's just legal training. It's not like a forced training. Like, make sure you don't put this in.
Yeah.
But again, all you need to do is make out a prima facie case based on the elements of the crime. You don't need to detail that he made a left and then a right and then step back and then step forward. No, he punched her in the face and that